this case against the defendant under the doctrine of breach of contract and breach of duty of care. Clearly, my client had been misled by the advertisement shown in the newspaper which induced him to buy the said product. However, the defendant themselves confirmed that the newspaper and claim was false. The defendant also owes our client duty of care to ensure that the product is safe and not at all defective. Here, the defendant is aware that the products have no Sundram approval or even imported with approval from Suruhanjaya Tenaga. The drill could very much be defective without any of this approval, Your Honour. We rest our case.
Your Honour, my client admits that the product in question has none of the said approval. They admit that they only did random checking on some of the boxes of said product. However, my client relied purely on the representation of the product supplier. They are not too concerned to ascertain the position with regards to the approval. The Sundram advertisement placed in the newspaper are also purely to attract customers because it will be good for sales. Your Honour, on the side of the defendant, we want to raise the issue of contributory negligence. We want to allege that the defendant had contributed to his own injury as the plaintiff applied excessive pressure in the use of the said product, which caused it to be defective.
The court will now give judgment for the case of Sundram, Veeriah and Magnificent digraphs in the Veeriah. Regarding the first issue, the court rejects the plaintiff's claim for breach of contract on the ground that the contract made was for the purchase of the product, which was precisely what the plaintiff did. Based on the arguments presented by both parties, the court is in the favour that the defendant is liable for breach of duty of care towards the plaintiff. In determining whether the defendant owes duty of care towards the plaintiff, the court will look at the three factors that need to be fulfilled as dictated in the case of Cabarro and Dickman. Firstly, there must be a close and direct relationship between the plaintiff and the defendant. According to the neighbour principle established in Donahue and Stevenson, the plaintiff and defendant are in a buyer and seller relationship, which is sufficient to prove close relationship between them. Secondly, any damage suffered by the plaintiff must be foreseeable. As the defendant only did random checking on some of the boxes containing the said product placed on the shelves of the defendant's hypermarket, it is foreseeable that they did not do a full checking on the product. By referring to the case of Watson and Buckley, and also Osborne, Garrett and Co Limited versus Wise Products Limited, the defendant ought to have known the particulars of the product. They should have at least confirmed that the product is Sundram approved and also approved for the importing of the said product by Suruhanjaya Tenaga. Thus, it is important to establish that the product is Sundram and Suruhanjaya Tenaga approved to avoid it being defective, which caused the injury suffered by the plaintiff. Thirdly, whether it is just, fair and reasonable to impose duty of care from the defendant to the plaintiff. The court is in favour that it is just, fair and reasonable to impose duty of care towards the plaintiff, as the injury suffered by the plaintiff would not have happened but for the negligence of the defendant. In the defense of the defendant, they had raised the issue of contributory negligence towards the plaintiff. However, looking at the evidence and the conduct of the plaintiff as a whole, the plaintiff had taken reasonable care and had behaved reasonably. Thus, the court rejects any plea of contributory negligence on the part of the plaintiff. In the upshot, I found liability in favour of the plaintiff and ordered the defendant to pay the plaintiff the sum of 10,000 ringgit as general damages with no order as to cause.
Your Honour, my client has